our continued efforts to reach the African and other ethnic communities in the United Kingdom with greater impacts and create a platform to hear your silent and unheard views in this hugely growing community in the United Kingdom. Our channel, Ben TV, presents to you another live current affairs television program. Our focus on the program is to review and discuss issues around the diaspora community in the UK. The program offers you that unrestricted voice on issues affecting you in the UK. Join us live every Monday at 10 a.m. to 12 noon. Another business segment of Dialogue in Diaspora, 2 to 3 p.m. every Monday. But guess what? You can be part of the program. Just send us an email at bentelevisionuk@gmail.com. Dialogue in Diaspora, your voice, your opinion on our TV. Thank you for being part of the program. This is Voice coming to you from Ben Television. This is a program designed for our community education, where we take a look at issues of legal matters in the United Kingdom and how it affects our community and how our community should live within the requirements of the law. And the program is Voice. My name is Tunde Alabi, and my guest in the studio today is Jennifer Obaseki. As usual, we'll be taking a look at issues around the law, most importantly, immigration matter. By the way, let me wish you Merry Christmas and Happy New Year. And as many of you will be preparing in order to travel out of the UK or to travel into the UK, it's important we observe the law, keep the law of especially people traveling into the UK, your family members that are coming into the UK. It is important they observe the law, keep the law, stay within the ambit of the law and operate within the law. That you have a visa, it is not automatic that you must be granted entry into the United Kingdom if you don't comport yourself. And that does not mean the visa cannot also be cancelled anyway. Jennifer will be telling us more about this and a couple of changes that have taken place within the immigration system, especially that's got to do with restricted leave to remain, and of course waiver rules and fee waiver and the rest of things like that. Let me bring to you our guest in the studio, Jennifer Obaseki, senior partner at Obaseki Solicitors here in the UK. Jennifer, thank you for joining us on the program today.
My pleasure.
Quickly, as people will be traveling in and out of the UK this festive season, what advice would you be giving to people? That people have visas to come into the UK does not mean it's automatic.
Yes.
Entry into
Some
the
things
UK.
you just have to be aware of. Just because you have a visa that allows you into the UK, it's been issued by the embassy. When you get to the point of entry, if you're asked questions and your situation is deemed to have changed, or if it's deemed that you presented evidence that it was incorrect in order for you to obtain your visa, you may be denied entry into the UK. Can I also add the element that if you're traveling, no matter where you're from, if you're going to your, let's say your country of origin, and you carry a dual nationality, check that the passport is in date. If you're leaving the UK to another country that is one that ordinarily would require you to have a visa, if you carry an expired passport, you may not be allowed to board the plane. Depends on the aircraft's policy. So, for example, if you have a Nigerian passport, check that it's in date before you leave the UK. If you go on to certain carriers, when you get to the airport, because you do not have a visa in your British passport, they may not allow you to leave. The other thing you have to be aware of is, if you actually have applied for a Nigerian passport, and because of the delays, you're either offered a travelling certificate or you're offered a visa in your British passport, you have to be, again, very careful. Because if you leave the country and you do not have your Nigerian passport, when you're leaving Nigeria, you will be asked by the Nigerian Immigration Service to get a visa on exit. Yes, a visa on exit, and it costs $180. So you have to be very, very
What's a visa
careful.
on exit?
That's the terminology that's used in order for them to ask you
to leave Nigeria?
Basically, the Nigerian Immigration Service say that if you enter Nigeria with an invalid document, and for example, you have a traveling certificate, you will still need to put a visa in your British passport because you have entered Nigeria on a document that is not
But if
100%
but
valid.
if
Believe me, it's happening.
but if you do have a travel certificate issued by Nigeria
It
High
allows you to
Commission,
leave the country, and it doesn't allow you automatically to come back in. And if you're coming back in using your British passport, then it means that basically you need a document that allows you to exit Nigeria.
so the
So you need to have
travel
a valid
document
document
only
with a valid
allows you.
visa to let you out of the country.
So the travel document only allows you to leave.
It allows you
Does
to
not allow
leave,
you to come
yes.
in.
It doesn't allow you to fly back out of the country. You're flying out on your British passport because your travelling certificate was a document that the Nigerian Immigration Service gave you to enter into Nigeria. And in order for you to use your British passport, the Nigerian Immigration Service are now making people buy this visa. And it is imperative that people know, because I've known people to get stressed and very upset at the airport and still forced to go and buy the visa, and it is actually issued downstairs in the arrivals lounge. And the unfortunate thing is, if people are not aware of it, they are severely stung at the airport, and many are not allowed to travel. So if you are traveling during this festive season, don't be desperate just because your embassy may have delays or difficulties in issuing you with a passport. Whatever it takes, make sure you have the correct documentation. So if that is getting a visa, as painful as it is as a Nigerian national, having to get a visa to go to your own country because the embassy has run out of booklets, you may have to do that. And if you're given a traveling certificate, you have to get some additional documentation that will state that you were allowed to travel in and out of Nigeria on that document. Otherwise, you will be asked by the carrier and the Nigerian Immigration Service to purchase a visa. And it sounds crazy, it sounds ludicrous, but we've been approached severally by different clients who have had this happen to them. And unfortunately, they have not been able to get refunds. It should be the embassy here that gives the reassurance that you can use it without backing it up with further letters. If you're offered a travelling certificate for one reason or another, insist that you do get this additional documentation. Otherwise, when you're levied with that $180 requirement in Nigeria, you've been forewarned by myself.
Okay, fantastic. Quickly, let's come back to the UK. Let's look at the issue of changes to restricted leave to remain or limited leave to remain.
Okay. In the past, you would be given discretionary leave to remain if you did not qualify for asylum. There was a form of DL that was issued. The DL stands for discretionary leave to remain, or humanitarian leave to remain. Now there's this restrictive leave to remain category that has been created, let's say that, by the Home Office, specifically being given to people who would ordinarily qualify for leave to remain as a form of protection. So it's formed out of the necessity to offer a period of protection to those individuals who would have their human rights breached if they were asked to leave the country. So they don't qualify for asylum in that they can't say that they're being persecuted in their home countries due to their religion, membership of a social group, political opinion. They can't say that their own government will not protect them and therefore qualify for asylum. But if they're saying, if I go back, my life, my liberty will be in danger because of the risk of harm that I will face if I go back to my home country, then there is that possibility that they can apply for or they can be receiving this restricted period of restrictive leave to remain. The important thing about it is, once the situation in your country is seen to have been relieved or dissipated, what the Home Office will look to do is then say, look, we only gave you a restricted, limited period to stay. You can now start making your way home. So if you still feel that there is a presented risk, if you still feel that your life will be in danger, if you feel that you'll still be treated in a degrading manner because the risk has not left, it's still there, then you will have to represent your situation and outline why your human rights will still be breached if you are removed. I know it sounds a bit of an overlap between the asylum and humanitarian leave under Articles 2 and 3. But basically, they're trying to stop the obligation to continue extending somebody's discretionary leave to remain. So if the regime in your home country is seen to get better, if the political social situation is seen to be better, so you will not face a risk to your life, i.e. under Article 2, or maybe there was a humanitarian disaster in your country and provision has since been put there, so it's not that you will go there, be destitute and face the risk of either poverty, starvation or otherwise, then the risk to you is seen to have been lifted, and therefore you will not qualify for any further extensions on that restricted leave to remain. So if you're given that form of restrictive leave to remain for one reason or another, be very clear it's temporary. See if you can then switch if you feel the need to or you qualify into another alternative category. Basically, the Home Office is trying to keep people in their lanes. You don't, and not extend it. If the track finishes, you can't continue going round by doing an extension. So it's very important that if you need to switch lanes in order to extend your stay, you do so in good time.
So, by implication, what the Home Office is saying is these 2.5 years discretionary leave to remain is not subject to automatic renewal.
This is even different. This is different from discretionary leave to remain. It's restricted leave to remain, number one. And number two, it may not even be for 2.5 years. It could be for 6 months. It could be for 1 year. And this is the thing about it is they're basically saying to you, at the end of this, you're expected to leave. You will not qualify for extension, and indefinite leave to remain. So if you need to switch out of this category, you need to do so early enough and get some comprehensive advice.
Okay, if you're watching this program and you're not sure where you belong, where you fall, maybe you have a limited leave to remain in the UK, which is 2.5 years, you're not sure on that work condition, you've been given that limited leave to remain in the UK, I think it is quite advisable that you speak to your solicitor so that your true status is confirmed now to you, and then they look at it with the current regulations in terms of immigration rule, so that you know if what you're carrying is a kind of discretionary leave to remain that is restrictive, so that you have an idea of what the situation is. I think you better speak to a qualified solicitor if you're having a 2-year and 2.5 years or less. Do not think it's automatic. I think your status should be confirmed. You speak to your qualified solicitor or Citizens Advice Bureau, or probably you want to write to the Home Office to confirm your true status. You don't want to probably take that risk. Then the best is to talk to a qualified. So you want to talk to us as you watch this program. The number to call or to text is going to be put on the screen. We might be able to direct you, give you appropriate direction through Jennifer Obaseki on the program. I think it is important. The rules are changing now, and the government is trying to make sure that it's a target on migration, although he's been criticized lately for keep missing that, but the government is determined, and so they're changing the goalposts, and the rules are also being changed as well. Don't be caught unaware, and that's with the issue of either discretionary leave to remain or restricted leave in the UK. Nothing is automatic. Just make sure you confirm your status with an appropriate solicitor. All right, Jennifer. Also, there is another issue of fee waiver. What's
so you've got to really remember the costs of these applications. And before we even think about the costs, even in this last month, the forms have changed almost 3 times. They've changed twice. The application forms have changed twice in November, and they've also changed on the 1st of December. So again, if you use the wrong version of the form, your application may be deemed invalid. So the form change, you must send the correct version of the application form with your application. So it's crucial that you look on the Home Office website for the correct version of the form that you need to use, first of all. The other thing, there is only one element of good news, which is the appeal fees has actually being maintained. There was going to be a hike of the fees by almost 500% from £140 to £800. The government passed the legislation, but I think just before they were about to put it into play, 2 days before or so, they sent out a change. There were many groups opposing this hike in fees, and it's wonderful that the Home Office or the Secretary of State has decided not to. However, it may increase, but not as substantially as they intended. Again, if you've got any passion about this subject and you have MPs, please lobby them, because it's going to cripple people who may have merits in their case. It will actually restrict them from accessing justice, in my opinion, because if you have a good merits in your case, but you're asked to pay £800 in order to lodge your appeal when you have next to nothing to live on, then, or even if you have a lot to live on, £800 is substantial. But so it could be a deterrent from people actually accessing justice, and a breach of their Article 6 rights, since the Human Rights Act is still in play and not got rid of yet. But looking back at forms, since the forms have changed so rapidly, again, make sure you have the right form. But if you look at the fees and you cannot afford the fees, then again, really, really look at the rules that surround the fee waiver. One, you have to show that you're homeless. So if there's an order for possession because you're in rent arrears, or you actually have been asked by whoever you're squatting with, sharing with, to leave the accommodation, evidence of that could go towards helping you have your fee waiver put into play. The fact is, even if you have accommodation and the accommodation is overcrowded, substandard, it's also evidence to go in support of you having a fee waiver. So if you can show that there's 4 of you living in one room, it's inadequate. It meets the definition. If the accommodation is also dilapidated, no heating, no hot water, or broken facilities in serious disrepair, it also goes towards the, supporting the fee waiver. The other thing you need to show is that you cannot meet your living needs. How do you show you cannot meet your living needs? You have to do an income and expenditure schedule showing that you cannot afford this big fee. You also have to show that you will not be able to save that money in the foreseeing 12 months ahead. So showing what is coming into your house, showing what you have to expend to maintain the family. You do it on a schedule, just list it out. Also show evidence of the bills you're paying. And then that also goes, so if you're able to show that you're, at the end of the month, you're left with £10, £5, very, very important. And at the same time, showing that you don't have anyone that can equally borrow you the money. They also look to say, okay, you may have friends, it's reasonable to expect you have people. They even go into your credit reports. So you have to really be careful. If you've gone to take loan or have credit cards, they will check your individual credit reports when you apply for the fee waiver to see that you've not even gone to get credit. And they'll go back and lean on it as a reason to refuse you if you have gone to go and get credit and not used it for a better reason, let's say. So you do need to be, let's say, more open to the idea, to checking if you qualify for a fee waiver before just, suffering the family or overstaying. Many people are overstaying because the financial burden that the, let's say, the application process and extension process puts on families is severe. It's so severe. And again, it's one of those things that I say, if it's really affecting you, affecting members of your community, speak to your MPs. It's only through Parliament that we can get these things changed. So there's been success with the appeal fees. There should be success with this. I've not known any other area of law, even employment law, they put the fees up to 200 or so to get to the tribunal. And even that has been seen as a burden or a barrier to people accessing justice. Talk less of migrant families who have low incomes and are vulnerable, who are asked to pay £800 plus the 300, so 1,311. So that is a severe barrier to anyone regularizing their status or, let's say, accessing justice and fairness in order to support themselves in the United Kingdom and, again, become compliant with the law. So if the law sets itself in a position where it's unattainable, is that justice? I don't know.
Okay, all right, Jennifer. Quickly, let's look at the people are watching this program, and they have actually tried a couple of immigration advisors, including solicitors, and very many have got their fingers burnt because they have actually approached immigration advisors and solicitors who are not up to date with the rules, immigration rules. And applications have been wrong, either wrong application forms used, or people just putting together Article 3, Article 2,
Human rights.
human rights application on every situation.
They'll do a discretion application for you.
Filing.
Nonsense.
If people are watching this program and have become victims of mismanagement of solicitors,
you have to realize that there's a two-stream tier. In short, there's a three-stream tier in the United Kingdom when it comes down to accessing immigration specialist advice. The first is you can go to somebody who's qualified under the OISC, the Office for the Supervision of
Office of Commissioner for...
The problem that you have with that is, number one, they only have 3 levels. So either a level 1, which is basic, level 2, which allows you to do little more complex applications, or level 3, which allows you to do even more complex applications. But it doesn't allow you to do...
Do you need professional help at a reasonable cost? At Obaseki Solicitors, we have experts in property law, human rights, criminal litigation, immigration, civil litigation, family law, business law, landlord and tenant law, employment law, Sharia law. At Obaseki Solicitors, we can provide you with advice and assistance at all levels. We have over 100 years experience in serving our local communities, and we have a new maritime and international law department. We can help you.
When I say a high detailed level, levels where you can challenge the Home Office for not applying the correct policy, levels where you can even challenge the first tier immigration judge's decision because they've made an error in law, progressing to the upper tribunal, and then on to Court of Appeal, or to the High Court by way of judicial review, or, since we're still there, to the Court of to the European Court of Human Rights. Now, immigration has become so complex that you do need a high-level experienced specialist to give you the advice and make the application for you. The second thing is you can go to a solicitor, but again, the solicitor should be, again, very detailed and experienced, not just taking on the area, have done it for a long time, appreciate the changes, appreciate what is the most up-to-date rules and regulations that apply to you. And then you can also go to a barrister for direct access, usually if you're dealing with complex applications or you have a complex appeal. Solicitors have rights of audience. Some OISC people of the higher level have experience and can appear in court, but it's not everybody. If you are a victim of somebody who has given you negligent advice or made the wrong application form, or even misled you to believe that you have an application and they've not made one, that's coming across a lot. People taking money, saying I'm going to make an application and doing nothing. Then you can, if they're a member of any of those professional organizations or legal bodies, it means you can complain to the OISC, if it's a solicitor to the SRA, and if it's to a barrister to the Bar Council. And they should have insurance, which means that you should be able to sue, to claim damages for what has going to be the effect on you for them making the wrong application or giving you wrong advice.
Okay, all right, so I should get that information. You have the right to sue any immigration advisor, any solicitor or barrister who has been negligent or has given you wrong advice.
Professional
or
negligence, yes.
Professional negligence has not lived up to the promise they have made to you. So you can sue them and then get some damages paid out to you, and then you can use that money to get really a good professional service from qualified solicitor. If you're not sure of your status, if you're not sure of the status of the solicitor that is dealing with you, you can practically ask him or ask your solicitor, sorry,
can you confirm your qualification?
Can you confirm your qualification?
The insurance must be displayed.
And which professional body you're registered with?
Correct.
Either the Office of Commissioner for Immigration Service, or RSA or the back
SRS, yes.
SRSA or the back council. You can confirm that for you to be sure, and because you're not going to be paying anything less than £500 minimum for service charge. How much do they pay now?
It depends on the qualification and experience.
But
a grade A solicitor in London is £267 an hour. That's a grade A solicitor. Most immigration advisors give estimated or fixed fees per application. So you've got to be very clear as well from the onset. What are you paying for? You don't go into Tesco's and be given a bag and they say food is inside. You have to know what you're paying for, whether you qualify for the criteria that the person has said they're going to make an application for you on, and they should give you an engagement letter or a client care letter that outlines what they have advised you, what they're going to do for you, and what is needed in order to meet that application that they've said they're going to do.
Fantastic. This is how far we can go on the program today. If you have any query or you're concerned or you want to get more clarification on some of the issues you have raised today, you can drop us a text message on the number you see on the screen, or you can give us a call, or you can join us on Twitter. My Twitter number is at Tunde C3, at Tunde C3. That's my Twitter number. Or you can call the number, text the number on the screen for more information on what we have discussed today. We will be able to take and attend to your queries on every information that's been given on the program today. My name is Tunde Alabi. It's been a pleasure to have you join us on the show. Jennifer, thank you for being part of the program today.
Thank you very much, and season's greetings to everybody.
Season's greetings to everybody as well.
Happy holidays.
Enjoy the rest of your day. Bye.
Our continued efforts to reach the African and other ethnic communities in the United Kingdom with greater impacts and create a platform to hear your silent and unheard views in this hugely growing community in the United Kingdom. Our channel, Ben TV, presents to you another live current affairs television program. Our focus on the program is to review and discuss issues around the diaspora community in the UK. The program offers you that unrestricted voice on issues affecting you in the UK. Join us live every Monday at 10 a.m. to 12 noon. Another business segment of Dialogue in Diaspora, 2 to 3 p.m. every Monday. But guess what? You know you can be part of the program. Just send us an email at bentelevisionuk@gmail.com. Dialogue in Diaspora, your voice, your opinion on our TV.